Today is the culmination of the past year's work with colleagues and friends who have given of their material and intellectual resources to bring to fruition the promise we made when we commemorated the life of the late Professor Ali Mazrui in October 2014, here in this very hall. At that time, we noted the towering intellectual legacy Mazrui had bequeathed upon us and the responsibility we have to live up to this legacy.
Professor Ali Mazrui was a giant of academic history who moved a nation and the world towards social justice, equity, and in the process moved billions around the world that believed in what he believed in. From his scope of accomplishment, from adoration that he had earned as an academic and peace icon who shared with us his thoughts and his fears through his golden writing depicting the vision of an African continent as depicted from today's Professor Mazrui First Memorial Annual Lecture under the theme Professor Ali Mazrui and the Kenyan Constitution, a legacy for the present time.
Ali Mazrui's focus was on constitutionalism as opposed to the provisions of the changing constitutions through the region. But it is important to remember that, as Professor Ogendo said, to have constitutions without constitutionalism is really a failure. And so too, to have constitutionalism without the thrust to bring in constitutions that reflected this is also an omission.
I think he quite liked that our process was very participatory, but he felt that that what we needed also, first of all, he saw the importance of the consultations we were doing. And he said once in another article that constitutionalism can never take root if there is no massive consultation with the people or engagement with traditional cultures or customs and legal precedents. And he has said more than once that one of the big weaknesses of our process, it didn't mean just us, but in Africa, is that we don't look to our African past. We look to what happened in Switzerland, what happened in America, what can we learn from India. But we didn't say what can we learn from our own thing. For example, I can quote, how many constitution commissions in Africa have bothered to find out how the Asante was ruled, or how the Kikuyu governed themselves before colonial rule, or how pre-colonial Somali achieved the miracle of having rules without any rulers.
Mazrui always believed that the constitution that exists entirely in the imperial language, English, necessarily creates a major linguistic gap between the constitution and the citizens. And that delays development of a constitutional culture in the country. The majority of Kenyans do not think constitutionally, partly because the constitution speaks to them in a foreign language. And this concern of Ali Mazrui has finally led to a more recent efforts to have the constitution made available in Kiswahili. Now, added to this is the fact that Article 159 of the Constitution now calls for the promotion of African or the traditional justice systems of dispute resolution. Now, those elders who will be hearing these cases will not be conducting the proceedings in English. It's most likely in Kiswahili, Kidigo, Kigiriama, Kikamba, Kikuyu, And there is a body of knowledge which I support, which basically says that the Constitution needs to be translated in Kiswahili first and then in these other languages, and that way we will enrich our jurisprudence.
Mazrui wrote prolifically, as always, about Africa, about self-determination on the continent, human rights, military governments, history, violence, and yet not enough on constitutions. And also, we miss, therefore, the lovely ironies that always peppered his writings. And what would he not have made? What about expecting him to write something about constitutions as the written words of oral communities? Or what about the Constitution as the instrument of anti-colonial success, and the same instrument as the same Constitution as the instrument of post-independence failure? These are little ironies that always, I think, he indulged in himself, but also they were they afforded tremendous sparkle to the profound things that he was writing.
Another issue of constitutional concern to Mazrui, and which he raised back in 1986, if not earlier, is that of gender inequalities. And he argued that throughout Africa, there's inadequate planning for the empowerment of women in the political process. And he made various suggestions, all based on what we have come to call affirmative action. He came up with 3 phases. Phase 1 was reserved seats for women in the legislature elected only by women, without prejudice to the rights of women as voters or candidates on the common electoral roll as well. And phase 2, reserved seats for women in the legislature elected by a franchise consisting of both men and women. And 3, abolition of special seats for women when the evidence showed a more balanced representation of men and women through a common electoral roll without the need of reserved seats. And if you look at the 2010 Constitution, the issue of gender equality and equity is central. We decided on the basis of the 2/3 gender principle, which, as you know, is being debated now. And when that matter came to the Supreme Court, my view was that 1/3 was the minimum, and that's where we wanted to start until we get to 50-50 or more than, or 60-40. But the majority decision was that the gender equity or one-third gender rule will be achieved, progressively. And I think the debates are still going on, and that's, in my view, another aspect of Mujomba's vision, the calling for affirmative action long time ago for women's representation in the legislative bodies, is very much the kind that has been adopted in the new Constitution.
One of the things that he thought was very important in a country which is multi-ethnic was the system of federalism. And because federalism is a system that provides for the sharing of power. Especially, I know, you will all remember, no less a place than Mombasa, the people of the coast hatched many plans. secession, of autonomy, and they felt they were different from people inland, and they wanted their distinctiveness, their history, their religion being acknowledged in the framework of the state, in the structure of the state. And Ali was very interested in that, and he wrote about that. And you may remember in 1960, as we were marching towards independence, there was much talk of Majimbo. And there has been ever since a lot of discussion about Majimbo. And Ali was in favor of Majimbo. Not just because he was an Arab, just because he came from this region, but because he sincerely believed that among the successful federations, Switzerland and to some extent India, Canada, federalism has provided a vehicle for peaceful coexistence. And he thought Kenya needed that too. And as you know, many other groups wanted. Majimbo was the big debate, controversial issue as we worked towards the 1963 Independence Constitution.
And instead of trying to sweep under the carpet as something unhealthy and dangerous, it ought to be addressed constitutionally. And towards this end, he rekindled the Majimbo debate in his short think piece entitled Majimboism, Economic, Political, and Military, that appeared in the local newspapers back in the mid-1980s.
And then he noted opposition from the then dean of the law faculty in Nairobi. He is now a governor. So you know who I mean. The governor of Makwini was the one who strongly attacked the idea of Majimbo devolution.
Kenyans had grown to appreciate Ali Mazrui's concerns, ultimately leading to the cardinal foundations of the new constitution, the principle of devolution, and that is the principle of equitable distribution of political power and resources.
Ali's understanding of what we call constitutionalism was relatively traditional. In one of his articles, he defines constitutionalism in this way. Constitutionalism in the broader society is supposed to be one of the anchors of stability, helping to define the rules of the game, helping to check the excesses of power, seeking to extend democratic rights and due process even to those who might go astray in economic deviance and who might manifest, now this I'll have to explain, sexual deviation. In one of his articles, and I'll probably say more on that later on, he was looking at the law in many countries which prohibits homosexuality or which prohibits extramarital sexual relationships. And he sort of comments on the basis of these prohibitions, but feels that it is no business of the state to, these are matters for individuals.
And his argument was that constitutionalism is not about relations between families and genders, perennial and vital as these are, nor is constitutionalism only about political participation and ethnic accommodation, crucial as these dimensions have to be considered. Constitutionalism is also about the limits of state power in the lives of private individuals. And he said, they say, an English home is his castle, ready to be defended by him even against all unwarranted officialdom. And under what circumstances is an African home his crown, ready to be defended by him even against state intrusion. Constitutionalism is therefore also about curbing of the state power from intruding too far into the private life of the individual. And he then went on to say, controversial as he always was, that if a man and a woman decide to live in sin and never get married, a democratic government and a free society should not interfere, even if they disapprove of the sinful lifestyle. And what he asked, which is, beyond what the Constitution has even dealt with, is a question, what about living together as homosexuals? Obviously, very, very, very controversial, but I had to read it because it's in print. So here is a man who could anticipate even disputes that might come, 50 years from now when we are dead and buried.
It is also surprising that when he is looking at the famous triple heritage, that he does not concentrate upon one of the most important and really iconic aspects of the Western part of his and Africa's triple heritage, which was the rule of law. Was he considering that his energies would go into inventing an indigenous form that led to his inclusion of the military in various aspects of government, so that he was looking at the things that Yash has spoken about? Was he in denial of this overriding yardstick by which nation after nation in Africa kept failing? So he was an experienced and an acknowledged and a good manager of academic institutions. He knew the value of and the need for written rules and systems of governance. But he gave little attention to national rules for national governance. And he left that to the contending forces in politics on the ground, while he was looking at the horizons to extend those very horizons in a way that could succeed.
He was not primarily a lawyer or legal scholar, but he had such mastery of related disciplines like culture, religion, history, philosophy, and of course political science, that he was well equipped to understand the purpose and the dynamics of a constitution. But it is quite possible, if things had worked differently, that he could have become a lawyer.
Ali Mazrui has written widely on a wide range of issues that are directly or indirectly relevant to the matters of the Constitution. And my conclusion is that, taken together, his views add up to a particular vision of constitutionalism anchored on the principles of inclusivity, fairness, and justice.
Whatever the busy writing that kept him, we miss his writing on this, and we miss him as always. Thank you.